Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
So welcome everybody to our podcast, International Arbitration Across the Pond. You know, it's been a while, and we're already starting off very rusty. We're trying to figure out what our last episode was. We're trying to figure out what episode number this is. And I think, Kwadwo, that we decided that this is episode number 14. Is that right?
Yeah, that sounds good to me, Chucky.
Okay, so we are happy to be back, and we are happy to have the discussion today, and we're happy to have our colleague, Rachael O'Grady. Hey, Rachel, why don't you say hello really quickly?
Hello, really quickly. Thank you for having me here.
Okay, yeah, no problem. So what we're going to talk about today is the interplay between climate change and investment treaty arbitration. And Kwadwo and I had a discussion before the episode, and we talked about what the title would be. So Kwadwo, why don't you tell them what our title is today?
Thanks a lot, Chucky. And you know, as regular listeners will know, we often debate long and hard about how to come up with the right snappy title for our podcast episodes. But for this one, what we've alighted on is the Investment Arbitration Treaty Climate. What we're covering and what that wraps up is the interplay, as you say, Chucky, between investment treaty arbitration and the all-important subject of climate change.
So, you know, this is really, the reason I'm excited about this episode is that it's educational for me, because we're talking about two topics that I admittedly don't know a lot about. And I was talking to Kwadwo about kind of the idea of a treaty, the fundamental idea of a treaty. I don't think is something that is as natural for a US lawyer as it is for a lot of international lawyers. So no, I think it's going to be an education for a lot of folks like me in the US as well as, of course, the other folks around the world. So Kwadwo, why don't you lead us off?
Thanks a lot. So yeah, Rachel, it's really fantastic to have you on the podcast. Obviously, I've known you for many years and known your preeminent practice in relation to treaty arbitration. And it's great to be able to discuss with you how that interacts with climate change and the considerations which are so topical here in the wake of COP26 and all the other urgent pressing news we keep seeing about climate change and the urgent need to address it. So we're conscious here that we've got two pretty major topics, and really from the beginning and for the benefit of our listeners, what we'd like to do is inspect how they overlap, interplay and interrelate. But before that, could we really start with the two individual frameworks separately? Perhaps you could ease us in by starting with the legal framework relating to climate change.
Sure. Well, thank you very much again for having me here today. And obviously, climate change is currently on everyone's radar in the aftermath of COP26 in Glasgow. But in order to answer your question, let's start from the beginning of the story. And to do that, we need to go back to the 1990s. So in 1992, in Rio de Janeiro, the UN Framework Convention on Climate Change, or the UNFCCC, as it's often called, was signed. And that framework convention was signed by 197 member states in recognition of the fact that global action was needed to combat climate change. But the UNFCCC was, as its name suggests, a framework convention only. So it just provided the overarching parameters within which nation states could then proceed to adopt specific binding protocols to achieve climate-related targets, which included limiting the global temperature rise to 2 degrees by the end of the century. And the UNFCCC provided at Article 17 for the creation of those protocols. Another thing that it did at Article 7 is that it established the Conference of the Parties, or the COP, which was intended to bring together member states on an annual basis in order to implement the objectives of the Framework Convention. So that is how COPs were created. So speeding forward to 1997, the Kyoto Protocol was then signed, which was an attempt by 38 developed countries to quantify and then set binding targets with respect to the reduction of greenhouse gas emissions. And then speeding forward again to April 2016, following the negotiations at the COP21 conference in Paris, the Paris Agreement was then signed by 175 countries, actually in New York, so not in Paris, but it was following the COP in Paris. And that agreement, the Paris Agreement, was significant because it was an agreement that essentially involved all countries, so not just the developed countries like in the Kyoto Protocol. And it represented a global commitment to combating climate change and a roadmap to achieve that. And that roadmap involved each member state setting its own nationally determined contributions, a phrase we're all very familiar with now, NDCs, with regards to its climate change commitments. And in addition to that, undertaking to progressively update those commitments every 5 years. And the COP26 that has just taken place was the first occasion on which those NDC commitments were renewed or set to be renewed since the Paris Agreement was signed. And so that very quick overview pretty much brings us up to date.
So thank you so much, Rachel, for that comprehensive and swift summary. Just as a brief recap for our listeners, could we just touch again on some of those acronyms you mentioned? I think we had UNFCCC, COP and NDCs.
Of course, yes, it's like another language. So the UNFCCC, so that is the United Nations Framework Convention on Climate Change. So if you add that all together, and the acronym comes the UNFCCC, so that was the framework, the umbrella legal framework under which the international climate change legal framework was to be developed and pursued. NDCs are nationally determined contributions. Those that is a concept that was created by the Paris Agreement in 2016, and it's basically in recognition of the fact that there are differing responsibilities between developed states, less developed states, developing countries in respect of the climate change roadmap. And therefore it's not appropriate for a uniform set of requirements to be set at a global level. And in order to reach consensus globally, of course, which is a very hard thing to achieve, it seemed to be of a fruitful way to do that, to get everybody to sign up to something that they all agreed to. And the way to do that was by letting each country set its own goals, essentially. But so it's nationally determined contributions, and signing up to do that, signing up to make those goals, and then signing up to progress them every 5 years. And what was the other acronym that you asked me to?
COP.
COP, of course, yeah, COP, Conference of the Parties. So COPs were set up by the UNFCCC, and that is basically an annual meeting of all the member states that signed up to the UNFCCC to annually discuss and address how to meet climate change goals and objectives.
Got you. Thank you very much.
Okay. Well, thank you for that helpful overview. I learned a lot already. But could you give us a similar summary of the legal framework relating to investment treaty arbitration for the benefit of our listeners? And then we can move on and talk about interplay between climate change and investment treaty arbitration.
Of course, yes. So international investment agreements can include bilateral investment treaties, between two countries, hence bilateral, multilateral investment treaties between 3 or more states, and they can also include other kinds of agreements such as trade and investment partnerships, or TIPS, just throwing in some more acronyms here to please Kwadwo, and free trade agreements, or FTAs, and so on. And just to give some perspective, there are currently well over 3,000 international investment agreements in force across the globe at the moment between various states. And the main purpose of these international investment agreements is to promote foreign direct investment. So they're entered into between 2 or more states, and in order to attract foreign investment into their territory, the contracting states to those treaties offer foreign investors certain protections in those treaties, and they offer to protect the investments that foreign investors may make. And those protections commonly include things like the guaranteed fair and equitable treatment of an investment by a state, or the guarantee against the expropriation of investments, a promise to ensure the full protection and security of foreign investments, and undertakings by states not to act in an arbitrary or discriminatory manner towards foreign investors or foreign investments within a territory. And so those are just some of the common protections. And if they are breached by a state, then a state's international liability is invoked under international law. And most investment treaties provide wronged investors with the right to bring claims in that scenario directly against a state via arbitration. And so investors regularly look to their rights under treaties when seeking to protect their investments in foreign countries.
Thank you for that.
And so the next question, I suppose, Rachel, so now that you've described, on the one hand, the legal framework in relation to climate change and environmental protection, and on the other hand, international investment treaties, are you going to tell us how these two important and previously unrelated frameworks come together and overlap, particularly in recent years?
I'm going to try to, yes. There are two examples in particular that spring to mind, which demonstrate this increasing overlap between these two international legal regimes. So the first is the very simple fact that the more global cross-border investment that there is in climate-related ventures, so be that in renewable energy, in transition technologies, in emission trading schemes, and so on, the more climate-related disputes that there will be arising out of those initiatives. So it's pretty clear today that there are whole new industries springing up as a result of climate change, and that the level of investment in those industries, including private investment, is huge. And because of much of it is international, a lot of it will be caught by or will be able to benefit from investment treaty protections. So a rise in activity will inevitably lead to a rise in disputes. And we have already begun to see that, particularly, for example, in the renewable energy sector. So that's the first example of how the overlap is emerging. The second example is the wave of new investment treaties, specifically incorporating environmental provisions. So as a result of the new climate-related obligations that states are signing up to and becoming subject to and are legally bound by, so as a result of the UNFCCC, as a result of the Paris Agreement, as a result of their NDCs, we're seeing a new wave of new generation investment agreements which incorporate environmental protections. And we're also seeing existing treaties, so some of those 3,000 existing treaties being updated to include similar environmental protections. And so this all shows that sustainable development related reform has made its way into today's investment policy making. So those are the two examples that I can think of.
Thank you. So a couple of questions I want to ask you based on your examples of the interplay. First of all, I like to understand a little bit. You said there are already some disputes, climate-related disputes, and I want to understand a little bit about what those disputes are looking like. Can you tell us what those look like?
Yeah, so for example, there have been a whole wave of cases related to the solar power sector. Many have been brought against Spain, and they are now being brought against other countries as well. and they have resulted from the passing initially by Spain and other countries of laws to incentivize investment in the solar sector by way of feed-in tariffs. So Spain passed these laws, and other countries as well, granting favorable tax treatments to those investing in the solar energy sector. So that attracted a lot of foreign investment. And then in the wake of the financial crisis, Spain and other governments revoked those feed-in tariffs. So investors that had invested on the basis on the expectation that they would be receiving that tax treatment, certain tax treatments, were then left without that treatment. And I think there have now been, it keeps changing every day. I think there are over 42 cases that have been brought against Spain on the basis of that regulatory change. And there are other cases as well being brought in Italy and elsewhere. But Spain is the one that's been hit with the most. So that's one example of the rise in climate-related increased activity that has resulted in increased disputes.
Okay. Any information about kind of how the arbitrations and how what's the status and how Spain is defending itself?
So again, there are the cases that are ongoing at a quick pace, and different tribunals have been constituted in those different 42 arbitrations. With 42 cases, you're inevitably going to get different results, and they're all based on slightly different facts. So there's now a mixture of results, basically, is the short answer to your question. There's a mixture of results.
Okay, got it. Thank you for that, Rachel. That's a great example. Can you also give us an example of what new environment-related treaty provisions look like?
Yes, of course. So there are provisions in these new investment agreements that simply flag the overall importance of sustainable development. So, for example, in the preamble or in clauses on a treaty's objectives. But there are also provisions that guide government behaviour and investor expectations. So, for example, clauses on a state not lowering its environmental standards to attract investment, and clauses encouraging investors to act in an environmentally responsible way. There are also provisions setting out exceptions, so exceptions to treaty provisions which would otherwise be available. So, for example, a state may be able to act in a way which would perhaps ordinarily breach a certain protection, but if its action was necessary to achieve a public policy or environmental objective, that may be accepted. And then there are also provisions setting out total exclusions. So where certain investments may be totally excluded from the scope of a treaty entirely for environmental reasons. So, I mean, off the top of my head, for example, hypothetically speaking, treaty provisions excluding fossil fuels and investments in fossil fuels, things like that, that may arise in the future.
Thanks, Rachel. So they're very interesting to hear about how environmental or environment-related provisions are actually being worked into treaties. Am I right in understanding this is something that's being considered in the context of the revision of the Energy Charter Treaty?
Yes, absolutely. So the Energy Charter Treaty, or ECT, as another acronym, revision process, that's something that's ongoing and underway at the moment. And the Energy Charter Conference has set out a list of topics to be reviewed as part of the reform process. And that includes, or those topics include, a state's right to regulate sustainable development, CSR, fair and equitable treatment, etc. And both the EU Commission and the private sector, both sides, have raised the need to align the updated ECT with the Paris Agreement objectives. So yes, in fact here, for example, there has been pressure, significant pressure, to carve out from the ECT's protection investments in fossil fuels. And if proposals like that are accepted, then it may mean that fossil fuel companies may not be able to bring claims under the ECT in the future, which arise from the impact of a state's climate policy.
This podcast qualifies for 0.5 CLE credits in Illinois and California. To claim CLE for listening to this podcast, please take a note of the following code, which is one word: Arbitration 12. That's ARBITRATION, followed by the number 12. Instructions on how to submit the CLE are included in the written description of this podcast.
All right, so what about investors? So did investors have environmental responsibilities under these new treaties as well?
Well, this is quite a complicated area because international investment agreements traditionally focused on state obligations, but obligations for investors, yes, are starting to emerge, and that may reflect a growing focus on the environmental impact of international investors. So, for example, in some recent treaties, it's been made mandatory for investors to carry out a full environmental impact assessment for any investment, or to maintain an environmental management system throughout the life of their investment. So yeah, provisions like that are starting to crop up.
Well, that's all very interesting to hear about these sort of developments, Rachel. But how is it that you actually see these obligations on investors being enforced? Do they amount to positive obligations on the investors that give states the right to either make claims or, I suppose, counterclaims in the event of breach? Or are they more likely to be used as defences that states have to deploy when claims are being brought against them by investors?
So again, this is quite a complicated but very interesting area of international law, and it's because of all of this, it's likely going to develop a lot over the coming years. So first, yes, it is true that environmental considerations are being increasingly used by states as defences. So in the sense that non-compliance with environmental regulations may deprive investments of protection. But the really interesting question is whether these investor obligations, so to speak, could ultimately be used by states to bring environmental claims or counterclaims against investors in treaty arbitration. And this hasn't happened yet, or at least successfully, because, well, of course, the whole rationale behind investment treaty protection is the protection of foreign investments. And it was never intended to be anything more. So the purpose of treaties was always to encourage foreign investment by granting rights to investors and not imposing obligations on them. Old generation bilateral investment treaties, or BITs, don't expressly address counterclaims, unlike some of the new ones. But the UNCITRAL arbitration rules at Article 21, which are frequently used in investor-state arbitration, and the ICSID Convention at Article 46 do explicitly refer to counterclaims, and in theory they allow them as long as tribunals have jurisdiction and as long as the counterclaim is closely connected to the claim. And there's some really interesting case law on this, but it's really complicated. But the main obstacle, in summary, to date, to the success of state counterclaims against investors is the difficulty of identifying specific obligations on investors under international law. And tribunals have been willing to conduct exhaustive analysis of potential international environmental obligations, which could bind foreign investors. And it's now generally accepted, following cases like Urbasa in Argentina and Avon in Costa Rica, both of which are very well known, that investors are not immune from international law per se. But despite all that, it has proved difficult for states to successfully establish that affirmative and enforceable obligations upon investors exist. So the short answer to your question is that to date, environmental counterclaims by states have not really succeeded against investors.
So thank you, Rachel, for that. So at least under a treaty, it doesn't seem like there's been any environmental claims or counterclaims by a state against an investor that have succeeded to date. But do you think that might change over the coming years for any reason?
Yes, I do. Though I think the same legal difficulties will remain that have already been identified in past cases. But if in the future a case does arise in which it's found that a positive obligation does exist on an investor under international law, and that obligation has been breached by the investor, then it is possible that a state counterclaim may succeed. And eventually investors may face standalone treaty claims by states. But even then, though, there will be a very high evidential burden to prove an investor's consent to arbitrate international law claims brought by a state against it. So that may or may not put states off bringing those claims. But I think what's likely to be more common in the future is that states will increasingly, when faced with an investment treaty claim, I think they'll increasingly just make environment-related counterclaims against investors, regardless of the merits, and that foreign investors whose activities in any way impact the local environment of a host state will therefore have to be ready to face public scrutiny of their activity and of allegations of environmental damage. So I think the risk landscape for future foreign investment will change as a result of climate change. And of course, with time, it may be that environmental regulations or international environmental regulations are adopted, which will be enforceable against both states and private investors. And that could lead to damages awards against both state and non-state parties. And in fact, in the face of that possibility, investors may even be dissuaded from initiating arbitrations under treaties if their own conduct has been questionable, because of course it's all in the public, or often in the public domain, and they may not be willing to expose themselves to that risk.
So what, just one quick follow-up question. So what legal framework would impose those obligations on the investor in this context?
So it could be some sort of new international convention on climate change. So like the International Convention on Human Rights, that could arguably, well, and that does arguably impose obligations on international investors operating under international law. It could also be, in the wave of new treaties that we're seeing, the more treaties that expressly place obligations on investors, the more that will become part of international law as well. And investors investing in a country will then become subject to those treaties.
That's all very interesting, Rachel, and I'd be keen to watch and see how this issue with counterclaims develops, if it does, and it certainly touches on some interesting points of international law. But leaving that issue to the side for a minute and looking back at straight claims made by investors against states under investment treaties. You mentioned some of the solar claims that we've seen in Spain. What other types of climate-related claims have arisen to date, and what might we be expecting to see in the future?
Well, so as a result of all of the new obligations on states and the increasing public pressure on states, states are adopting new laws, new policies to combat the effects of climate change. And it's many of those new measures that we're now starting to see overlapping in the investor state sphere. So two examples, I suppose, of situations that may give rise to disputes with investors are, first, if a state fails to take action to implement climate change. And secondly, if a state does take action to implement climate change. In both of those situations, a scenario may arise where the existing investor protections in treaties are potentially compromised.
Can you explain that a little bit further?
Yeah, of course. So taking the first example, a failure by a state to act to implement climate change or taking action against climate change states are now subject to new international obligations, so thanks to the Paris Agreement and so on. And investors should and will expect host states to adhere to those new climate-related commitments as part of their fair and equitable treatment and full protection and security obligations under treaties. So in this context, for example, an investor whose investment suffers damage from climate-related weather conditions, for example, as a result of a state's inaction, may be able to bring a claim for breach of the full protection and security standard in a treaty. And because whereas that standard has traditionally linked to a state's guarantee to protect against physical harm, such as the destruction of property, tribunals have also considered environmental damage to an investment as a novel example of physical harm. And it's also perhaps worth noting that the proposed revisions to the Energy Charter Treaty that we discussed a bit earlier would impose specific obligations on a contracting state as they're currently drafted. I mean, they may change because they're just proposals, but they may impose specific obligations to implement the Paris Agreement and to implement a state's NDCs. And so that and other similar provisions may provide legal basis for investors to bring claims against states based on their inaction and breaches of their Paris agreements. Of course, it'll always be difficult in terms of evidence. How can an investor prove that a state's action or inaction causes environmental damage? But it would be interesting to see how that's overcome. So that's a state's failure to act.
And looking too at I suppose the opposite scenario to that. So essentially, where a state does act, and then that therefore gives rise to a potential claim. How exactly would that materialise? Is that something you can expand on a little bit more?
Yeah, of course. So that may arise where, for example, a state passes a new climate-related legislation or law that may conflict with existing investor protections and treaties. So the array of legislation that states have passed and will need to continue to pass in order to adhere to their Paris Agreement obligations is substantial. And while of course it's necessary to comply with climate obligations under international law, there is a risk, and states should therefore be alive to that risk, that in certain cases, such new legislation and policy may conflict with existing protections in investment treaties, which states are internationally bound to afford to foreign investors. So taking a very basic hypothetical scenario, if a state decides to phase out the extraction or use of fossil fuels, and it passes legislation to do that, it may face claims of expropriation from foreign investors who have invested in that field. And as I touched on earlier, in some cases, there will be a provision in the underlying treaty that carves out from the protections that it offers to foreign investors a state's right to act and a state's right to regulate in the public interest. But this all bears on the current debate over ISDS mechanisms or investor state dispute settlement mechanisms in relation to the balance that has to be struck between, on the one hand, the protection of the investor's rights, and on the other hand, the right of the host state to regulate. And that balancing act fuels concern and has fueled public concern about what's been known as a regulatory chill in the climate context. And that means where states don't take action through fear of claims being brought against them by investors. And this new wave of investment treaties addresses that to some extent. But with respect to the existing investment treaties, all 3,000 plus of them, the absence of climate-related obligations or carve-outs relating to the protection of environmental rights is potentially problematic.
Okay, thank you for that. So regulatory chill, huh? I learned something new today. Okay, it's interesting. Just for my U.S. folks, just a quick translation. the expropriation that you talk about, we usually call that a taking. You know, that a taking is kind of how the semantics that we use to explain what you're talking about. But I guess one thing that I'd like to hear from you is the balancing that you're talking about between a state's Paris Agreement commitments and whatever commitments they have under older generation investment treaties. How do you see tribunals kind of addressing this balance that states have to address and that's fine line they have to walk when disputes do arise?
Yeah, so a lot of the issues arise now from the potential conflict between Paris Agreement commitments and investment treaty commitments. And the Paris Agreement doesn't address how those conflicts should be dealt with between its provisions and existing instruments of international law. So tribunals may possibly look with increasing frequency towards Article 30 of the Vienna Convention, which sets out general rules under international law for resolving conflicts between treaties. And that specifies that when parties to an earlier treaty, so for example, a bilateral investment treaty, are also party to a later treaty, so for example, the Paris Agreement, the earlier treaty applies only to the extent that its provisions are compatible with those of the later treaty. But, and there is a but, Article 30 is only designed to cover treaties which relate to the same subject matter. And that may not be the case with a BIT in one hand and the Paris Agreement in the other. So difficulties arise in applying Article 30 when different treaties on different subject matters nevertheless still overlap on certain issues. But I think that tribunals will come to expect investors to be increasingly more recognizant of the fact that frequently host states will have entered into environmental commitments. I mean, as I said earlier, most countries around the world have signed the Paris Agreement now, and any investments made subsequent to those host state commitments, subsequent to the Paris Agreement, they must have taken into consideration when the investment was made those commitments, and that in turn must have influenced an investor's legitimate expectations. And I think in the coming years, with the increased focus on climate change and the necessary race towards net zero, and with states implementing stronger climate policies with higher carbon emission reduction targets and so on, I think environmental factors will likely become an increasingly mainstream factor considered by tribunals in investment disputes, and particularly as tribunals become more willing to recognise the right of host states to regulate in ways that protect the environment and advance climate action.
Well, that's incredibly interesting to hear all that set out, Rachel, and thanks for explaining all that so clearly. And I think really these latest developments in relation to climate change and the legislation and regulatory change, which is going to come to have any chance of achieving these ambitious goals, just brings back into the fore this perennial debate in treaty disputes and in relation to bilateral treaties more generally, which is that balance between a state's right to regulate and the protection of rights of investors. So it's been really interesting to hear you talk through that and really everything you've worked us through on this talk. I mean, I think what's absolutely clear is this interplay which you've been describing between treaty disputes on the one hand and the increasing and burgeoning volume of climate change regulation and legislation, which we're going to see continuing going into the future, is going to be a key theme in the future of investment treaty arbitration.
Yeah, I agree. And I think the movement towards climate change and the corresponding legal effects of that movement will also, of course, affect the international investment landscape. And the coming together of these two legal orders it's inevitable, and we're already seeing it, will give rise to a growth in investor state claims in this field.
Okay, well, thank you for all of your insights today, and it was interesting, and look forward to see what's coming along in the future with this interplay between climate change and treaty arbitration.
Well, thank you for having me. It's been a pleasure.
Yeah, I'd just like to say thank you so much, Rachael. Really, really appreciated you sharing your time and insight. And I, for one, am certainly educated and enlightened in both of these two very interesting areas. So once again, thanks so much for joining us on the podcast.
As previously mentioned, this podcast qualifies for 0.5 CLE credits in Illinois and California. To claim CLE for listening to this podcast, please take a note of this second code, which is all one word, 22 climate. That's the number 22 followed by the letters CLIMATE. Instructions on how to submit for CLE are included in the written description of this podcast.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo, Sarkodie or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcasts. Thank you for listening.